Good morning, and welcome to the second of a two-part webinar series on the implementation of an updated tool to conduct all appropriate inquiries. That tool is ASTM E152713, entitled Standard Practice for Environmental Site Assessments, Phase 1 Environmental Site Assessment Process. Our goal in this webinar has been to give you perspectives on the new ASTM standard from both a legal and environmental consultant point of view. My name is Barry Coggett, and I'm an attorney with the law firm of Bond, Schoeneck King, participating in the firm's Environmental and Energy Practice Group. I will provide the legal perspective. My colleague, Ben Height, a professional geologist from GZA, will provide the environmental consultant perspective. We welcome questions during this webinar. They can be raised via the chat or question box located in the GoToWebinar control panel on the right-hand side of your screen. If we do not get to your question, we'll follow up by email. Part 1 of our webinar was held on March 5. During that session, we examined the 3 overview questions that are listed on slide number 3. That is, why do a Phase 1 environmental site assessment? What's new in conducting a Phase 1 ESA? How is a Phase 1 ESA conducted? As to the first question, we do a Phase 1 environmental site assessment because of the environmental remediation liability that an owner-operator can have by reason of its status as an owner-operator of real property that has problematic environmental conditions. The principal statutory sources of that liability are the Federal Superfund Law that goes by the acronym CERCLA, the New York State Superfund Law, and the New York Navigation Law. The costs of responding to address a problematic environmental contamination can be a liability to the owner-operator, and that liability is strict, joint and several, and retroactive under these statutory authorities. To address the concern over the possibility of assuming a significant remediation liability, the EPA has set up an All Appropriate Inquiries, or AAI program, that is intended to require one to examine the environmental conditions of the property and thereby learn whether there are recognized environmental conditions that could give rise to potential environmental remediation costs. This led to EPA's approval of the use of ASTM International Standard E152705 method in November 2006 to satisfy AAI. What's new in conducting a Phase 1 ESA is that ASTM updated its Phase 1 ESA method with ASTM E152713. This update was initially offered as an alternative to the existing ASTM method, but in June 2014, EPA proposed to delete the option of using the earlier method. In October 2014, EPA made the deletion of the acceptability of the earlier ASTM method final, so that as of October 6, 2015, only the new ASTM International Standard E152713 method will suffice for purposes of satisfying EPA's All Appropriate Inquiries requirement. Then in our March 5 webinar, Ben walked us through the actual performance of a Phase 1 environmental site assessment, highlighting the changes under the updated ASTM standard. Access to a recorded version of that webinar session can be accessed through the Bond website under videos. In our webinar today, we're going to review a number of topics that we would describe as potential potholes relative to the performance of a Phase 1 environmental site assessment. These topics are listed on slide 4, and the first one is hiring the environmental consultant. The first thing is you have to hire an environmental professional, or EP, as defined under the EPA's AAI regulation. An EP is one that holds a certain professional license and has the equivalent of a certain number of years of full-time relevant experience. There is also an option of someone having an equivalent of 10 years of full-time relevant experience without a professional license. So one needs to verify at the beginning who is the environmental professional who will be responsible for the work, and that the one selected qualifies under one of the environmental professional categories. It is not necessary that the individual in the field who is doing the work have the qualifications of an environmental professional, so long as that individual is working for someone who does qualify as an environmental professional. Now, there is a need for relevant experience in each of the 4 environmental professional categories. Relevant experience is defined at 40 CFR section 321.10 to mean what you would expect. And that is that this individual has been involved in the conduct of all appropriate inquiry investigations and environmental site assessments, and as a result of that experience, understands what the certain environmental conditions are that would give rise to the possibility that there could be releases or threatened releases to the subject property. The bottom line is that when you are preparing the agreement with the consultant or looking at that proposal, there should be a requirement that the environmental professional requirement is met and that the work will be done in conformance with 40 CFR Part 312. If the Phase 1 environmental site assessment follows ASTM E1527.13, the all appropriate inquiry requirement will be met under the EPA rule. To ensure that all the required items in the standard are addressed, the ESA report should follow the recommended table of contents in the Phase 1 report format that is found in the ASTM standard. In the consultant agreement, you also need to clarify what non-scope items are to be addressed. Sometimes, due to the press of time, there are provisions to do a limited Phase 2 or invasive investigation, so that all the environmental information comes together sooner as opposed to later. Looking at the headings which are found at the appendix to the method in X4, that's the X4 appendix, and they're all listed. I will now turn the program over to Ben, who will go over what is to be in the ESA report, as you can see beginning on slide 9.
Thank you, Barry. The summary section simply summarizes the process and includes findings, opinions, and conclusions of the environmental professional. An introduction will include the location and legal description of the property, such as the address, intersecting streets, and property tax ID number. It will include the scope of work and the purpose of the Phase 1. It will include limiting conditions, deviations, exceptions, and assumptions. The user-provided information obtained from the questionnaire will be discussed. This can include information on liens and prior or specialized knowledge pertaining to the site. The Records Review section will discuss all data obtained from the FOIL requests and government database review. The Site Reconnaissance discussion will review observations obtained from the EP's visit to the site. This will include the site setting, such as the use of the surrounding area, interior and exterior observations, and uses and condition of the property. Interviews with past and present owners and occupants will be presented. The evaluation section includes the environmental professional's opinions as to what wrecks, if any, are found. Data gaps will be presented. The environmental professional will include their statement, references, and signature. Non-scope services, items we'll touch on later, are discussed. In this section, the EP will summarize recommendations for additional services outside of the scope of ASTM 1527. Finally, the appendices will include all the supporting documentation, such as historic reports, database search results, photographs, and the EP's qualifications. The environmental professional's opinion is the root of the Phase 1 report. Has the AAI inquiry identified conditions indicative of releases or threatened releases of hazardous substances on, at, in, or to the subject property? The EP's opinion of, if, and how wrecks may have impacted the property will include their logic and rationale for including or excluding a condition as a wreck. Wrecks are subsequently summarized in the summary section of the report. The EP will provide an opinion if additional investigations are appropriate to further characterize a wreck. hazardous substances, or petroleum products. This can include soil, groundwater, or surface sampling. Such recommendations are not required. The report is considered complete if recommendations are not made. An example of where an environmental professional may recommend additional investigation could be a case where the property was used as a retail gasoline station 20 years ago and has since been decommissioned. However, there are no records or documentation of tank removals, soil sampling, or regulatory oversight. This would be considered a data gap and could be filled by a subsurface Phase 2 investigation. Identification of significant data gaps that affect the ability of the EP to present opinions on RECs, such as the case of our former gas station, are very important. These data gaps can typically arise from lack of input by the user, such as failure to return the user questionnaire. Lack of access to the property or portions of the property due to locked doors or unsafe conditions are also common sources of data gaps. The environmental professional will present conclusions and a summary that discuss the RECs found at the property, specifically the presence or likely presence of any hazardous substances or petroleum products in, on, or at the property due to release to the environment, under conditions indicative of a release to the environment, or under conditions that pose a material threat of a future release to the environment. The revised standard includes a new term we briefly touched on 2 weeks ago, a controlled recognized environmental condition. This is a REC from a past release to the environment that has been remediated to the satisfaction of the regulatory authority using a risk-based approach, whereby the spill has been cleaned up to standards that do not provide for unrestricted use of the property. While the regulatory authority has issued a no further action letter to the responsible party, elevated concentrations of contaminants may remain and may be controlled through engineering practices, such as maintenance of an impervious surface or operation of a sub-slab vapor mitigation system on site. A CREC could hinder redevelopment of the property. These are presented in the findings section of the report. Finally, the appendices will include a site map, usually including the vicinity of the property, a site plan, site photographs, historical research information such as city directories, regulatory records documentation, interview documentation, special contractual provisions between the user and the environmental professional, and finally the qualifications of the environmental professional in the form of a resume or curriculum vitae. It is very important to appreciate the EP's limitation of liability. Potential liability to the environmental professional may be very significant relative to the cost of services. Phase 1 investigations are inexpensive relative to the potential liability. The EP should carry errors and omissions insurance, which will cover them in the event any significant errors are found later on in the report. The EP's terms and conditions should include a dollar amount of their limit of liability. Liability is also inherent in the reliance of information from others, such as past reports and interviews.
And in terms of determining the liability amounts, what do you recommend, or what is the practice?
It's generally left up to the consulting firm that the EP works for. Generally, if we have an existing client that we've known for years and have a very good working relationship with, it's easier for us to be more comfortable at a higher limit of liability. If it's a new client we haven't worked with before, we're not inclined to raise our limit very high.
Do you use the amount being paid to you as sort of the standard, or a factor off of that, or is it some other criteria?
It is factored into it. There's no set rule, but certainly if we have a very large project, then we're more willing to negotiate the limit.
The other point that's on this slide is confidentiality. And a seller, for instance, may want to do a Phase 1 environmental site assessment for his own purposes and keep the contents confidential. In that scenario, the attorney would retain the consultant. However, it's important to know that even though the attorney may have retained the consultant, this does not mean the consultant need not comply with reporting obligations. There is currently in the petroleum bulk storage regulations, that is 6 NYCRR Section 613.8, entitled Reporting of Spills and Discharges. It currently reads that any person with knowledge of a spill leak, and discharge of petroleum must report the incident to the department within 2 hours of discovery. This is usually more of an issue in the course of an invasive Phase 2 investigation than a Phase 1 investigation. However, it is always possible that someone walking the site may come across an above-ground petroleum storage tank that is leaking. The prospect of that happening should be covered in the agreement with the current site owner to access the property.
Submission of the ESA report to third parties is related to the discussion of relying on information from others. As an EP, if I am granting authority to a third party to rely on my work, I am opening myself and that third party up to liability. The third party, typically another lender or buyer, may request a user reliance letter allowing them to rely on the Phase 1 ESA report. The EP will not typically issue one. Reliance letter is not in the standard. If it is issued, it should include strict restrictions and outline unauthorized uses of the ESA.
And Ben, I would agree with that, I think, from the attorney's perspective. I mean, first of all, in the case of the seller having retained the consultant to do a Phase 1 ESA for his own purposes, that seller would have paid for that ESA himself. In terms of insurance, the insurance would run to the seller and not to this third party. There are certain contractual limitations and responsibilities that are outlined, which again would run directly to the seller. The confidentiality, if the attorney is involved, is running from that seller to the attorney to the consultant. So the thought of now turning that over to a third party and offering that as reliance, I think is inappropriate, and I agree with you, is disfavored.
When we do use prior Phase 1s, it's important to note its shelf life. The report can be updated if it is less than a year old by updating specific items, including interviews with past and present owners, operators, and occupants, review for environmental cleanup liens, record reviews, visual inspections, and the environmental professional's declaration. It's important to note data gaps created by additional requirements in the new ASTM standard will need to be filled if the prior Phase 1 was completed under the previous standard. However, prior Phase 1 ESAs can be quite useful, even if they cannot be relied upon. They can guide the environmental professional in their work by presenting information on known spills or wrecks. Interviewees in old Phase 1s may no longer be available. This can go a long way in presenting the history of the site.
That brings us now to points of potential conflict. The conflict with the environmental professional may come as a result of a different point of view, which is held by the user, the seller, the third party, an attorney, even the buyer.
Coordination between the user and the environmental professional is key to a successful Phase 1 ESA. We've already discussed the importance of user-supplied information. There must also be an agreement between the user and the owner of the property that allows the environmental professional access to the property. And as Barry previously mentioned, the reliance and responsibilities of reporting a spill should be included here as well. The EP's conclusions will include a discussion of any wrecks. Has a historic recognized environmental condition become a wreck due to revised regulatory standards? The significance of data gaps will be discussed, as will any recommendations to proceed with a Phase 2 to fill those gaps. The lender may exert pressure on the user to conduct further investigation. It is important that the environmental professional communicates upfront the responsibilities of the user. Typically, these are presented with the environmental professional's proposal to do the work. The standard relies on the user, the entity seeking the CERCLA liability protection, to provide information on the existence of environmental liens, specialized knowledge of or experience with the property, the relationship of the purchase price to the fair market value of the property if it is not contaminated, and commonly known or reasonably ascertainable information about the property. Regarding the fair market value of the property, if one concludes that the purchase price does not reflect that value, it must be considered if it is due to the presence of releases or threatened releases of hazardous substances. User responsibilities are outlined in Section 6.1 of the standard and summarized in the suggested user questionnaire format in Appendix X3.
This brings us now to environmental liens, and there are two environmental liens that I will touch upon that come under CERCLA, and then one that comes under the New York Navigation Law. This first one here is under Section 107L of CERCLA, where an environmental cleanup lien in favor of the United States arises on property subject to or affected by CERCLA response action when EPA incurs costs for the cleanup, either removal or remedial costs, and provides written notice of that potential liability to the owner of such property. As noted, that lien continues until, in fact, the liability is satisfied or otherwise becomes unenforceable through operation of the expiration of the limitation period. I have not seen this lien come into play to this point. Probably one of the reasons is that if the EPA was involved with that piece of property, we would have been dealing directly with the EPA and addressing the issue of response costs right up front, rather than coming upon a property and discovering in the course of a phase one that there is an environmental lien. But that is, in fact, something that the EPA can insist upon, this particular cleanup lien. The second one comes in the category of that bona fide prospective purchaser who is able to purchase the property even though there is contamination. And as noted in our March 5 webinar, there are certain obligations that that BFPP must comply with, including allowing the EPA to come on the site and continue with remedial effort and allow certain reporting and access, etc., to in fact proceed so that the property can be cleaned up. So that means that that particular piece of property now at the end of the remedial action is now more valuable. And so CERCLA, Section 107R, says that EPA is entitled to grab that delta, that amount of additional value as a result of the cleanup. And again, this is referred to as a windfall lien, and that is an opportunity for the EPA, but again, not one, at least that I have at this point, have seen. The one which is a lot more common here in New York is the one which is available to the state of New York under the New York State Navigation Law, where the fund, the Petroleum Compensation Fund, when they incur costs for the cleanup and removal of a petroleum discharge, they are entitled to place a lien on that property as security for the payment of that of those monies that in fact are incurred. Now that goes on the property. When it goes on the property, it does not impact prior security interests like a mortgage that may already be on the property, but it is a lien. It can be enforced as a lien on the property, and it's something to be mindful of. And the fact that there may be costs incurred is something that one could determine when one is doing their regulatory review, searching the databases to see if there have been any petroleum releases, any open spill files, and that will get you into discussion as to whether or not there is a series of costs for which there is this potential for a lien to be recorded. So how you find out about the possible presence of an environmental lien? Starting with the user and asking that question directly of the user, picking up on the questionnaire that Ben alluded to. There is a model, a sample questionnaire that's in the method itself that one could use. We've seen that each environmental consultant modifies it slightly to get additional information or information in the way that's most useful to them in terms of preparing the report. Various EPA databases. There was a surplus database which is now being modified by another federal database, but it's possible to go on EPA website and find where they have incurred costs. National Priorities List has those sites which are particularly significant. County clerk's records will let you know whether or not there has been that petroleum lien that has been filed that secures that liability for costs incurred in cleaning up the petroleum.
Agency file reviews are typically obtained through a Freedom of Information Law or Freedom of Information Act request. These requests are usually initiated via a standard 1- or 2-page form that the EP completes and emails or faxes to the agency. It will include the property address and legal description and a summary of the requested records. The agency may provide access to the records by sending digital copies via CD, providing access to the records at the agency's office, or copying and mailing them to the EP for a fee. The agency can request additional time above and beyond the standard 20-day turnaround time. One item of note here is the new requirements by the administration of New York to delete any emails older than 90 days. And as of this week, the administration and assembly are going back and forth over what that means and who's actually covered under the new rule.
It's been noted, it's been reported in the newspaper that Governor Cuomo is negotiating in terms of the pushback he is receiving on this policy, which he is now implementing, and as to whether or not he may get perhaps the legislature to allow the scope of the Freedom of Information Law to reach their email traffic is one of the issues which is being considered. So it'll be interesting to see how this finally resolves itself. But the concern for someone looking at the particular history of the property, it could be that a particular person working for the DEC, for instance, would save more information, and I understand that there are guidances that may allow them to save certain information beyond the 90 days, but obviously a concern if there is this automatic deletion of emails, because oftentimes the back and forth does reveal some additional information about the property's condition, which is very helpful. This leads us now to the category known as business environmental risk. The ASTM standard defines business environmental risk as a risk which can have a material environmental or environmentally driven impact on the business associated with the current or planned use of that parcel of commercial real estate. And it's not necessarily limited to those environmental issues which are investigated as part of the standard method, but they are things that may in fact impact the ultimate use of the property. And so there may not be an environmental condition which may require environmental cleanup, but there could be situations which would impact the planned development of the property, and they're environmentally based. Now, the common non-scope issues, one would look at Appendix X5 of the updated ASTM standard to give sort of a summary of their view of those issues. And the non-scope items here are listed: asbestos, wetlands, mold, radon, ecological and historic resources, lead-based paint, lead in drinking water, indoor air quality, regulatory compliance, and this last one here, PCBs and building materials, is something which has come up of late. It's not listed as one of the items in the non-scope items, but when we get to that, we'll talk about why that's becoming more of an issue.
Asbestos can be one of the more costly remediation jobs when deciding to rehab a building. Asbestos was incrementally banned between 1973 and 1978. So the general rule of thumb is if your building was built after that, you should be free of asbestos. But if it's before 1978, then it's recommended to do a asbestos inspection. Suspect material can include pipe insulation, floor tiles, wallboard, and fireproofing. Fireproofing was one of the main benefits of using asbestos in building materials. There are a number of ASTM standards that asbestos inspectors use, including E1368-14, which is the standard practice for visual inspection, and E2356-14, which is the standard practice for comprehensive building surveys. The liability of asbestos is very high. The regulations are strictly enforced. Only New York State Department of Labor licensed contractors are allowed to sample and remediate asbestos. And there has to be separate agreements for the remediator and the monitor. So the same firm can't do the same two tasks. An example recently, in recent years, the local case was in Cayuga County in 2007, where a responsible employee who mishandled asbestos ended up spending some time in jail. And at one point he faced up to a $250,000 fine for his actions. Here we have a suspect asbestos-containing material in the form of pipe insulation, very commonly found in older buildings. And here we have suspect asbestos-containing wallboard. Now, it's important to note that if you do come across this, it is much more expensive to dispose of asbestos than standard C&D disposal.
Asbestos is, as Ben says, very heavily regulated. You have federal regulations. EPA has a set of regulations dealing with regulated asbestos-containing material. OSHA has a set of rules, a very extensive set of rules dealing with asbestos, and the New York State Department of Labor, 12 NYCRR Part 56. First of all, asbestos can be a wreck. It is possible that you may go onto the site and find in the back 40 there that someone has left a pile of friable asbestos. So it is, in that situation, it would find its way in the ASTM report as a recognized environmental condition. But simply having asbestos-containing floor tile or pipe insulation would not necessarily be a wreck, but certainly a potential issue with respect to the management of that property. OSHA has rules which deal with the need for building facility owners to determine the presence, location, and quantity of asbestos-containing material or presumed asbestos-containing material at the work site. For those who are working in housekeeping activities in areas which contain ASTM or PACM, they need to know the presence and location in areas where they may be involved in working near or on those type of materials. So it's a building management issue. And it's been noted when it comes to the point when you want to do renovation, then you're into issues under the New York State Department of Labor where you have to have licensed contractors to do the surveying, the monitoring, the abatement itself. There are notices that need to be given. There are standards that, in fact, need to be met. So it becomes an issue that needs to be taken into consideration, particularly if you're going to be purchasing that property with the understanding in the near term that you're going to be doing some extensive renovation. And so that would be a non-scope item that you would find up front in that agreement with the consultant to evaluate the presence of asbestos.
One of the larger issues that can affect development of property, especially a vacant property, is the presence of wetlands. They are regulated, and you can't just go bulldozing and fill in a wetland. Generally, you want to look for wet, depressed areas, just what you would think a wetland is, and vegetation that would indicate the presence of wetlands. ASTM used to have a standard. It was withdrawn in 2007 because it wasn't updated within the required time. And because of that, we rely on the U.S. Army Corps Manual, published in 1987, and subsequent regional supplements. The one here in New York would fall under the North Central Northeast Regional Supplement, which was updated in 2012. There are several, both state and federal, regulated wetlands. There are different definitions. The state wetlands are mapped, and there's the web address for the mapped wetlands for the state. You can simply enter an address and see the wetlands around you. It's important to note that a wetland as little as 1/10 of an acre can provide significant barriers to redevelopment. And beyond that 1/10 of an acre, there's a 100-foot buffer around the wetlands. So it's not just the wetlands themselves that can impede your development.
Picking up on that, that 100-foot barrier is only applies to a state wetland, and the state wetland is, as Ben said, they're mapped. They're large. They're 12.5 unless they're unusual wetlands that the DEC has decided to protect, but generally it's 12.5 acres. And again, you do have that additional 100-foot buffer that protects them, and so there is a need to put that into the calculation in terms of developing in that area. What people don't realize is that there is no federal map. That's referenced there is this National Wetlands Inventory, which gives you maybe a rough idea of areas that may be considered to be wetlands, but the only way to really know is, as Ben noted, getting somebody out there using the Army Corps manual to actually map out areas to see if they have the characteristics of a wetland. And it's possible, given the size, it may be appropriate to use a nationwide permit to perhaps do some development in a narrow way. Otherwise, if anything significant, you're going to be talking about a need to get a full Army Corps permit, and that can be a difficult task for a number of reasons, one of which now you're not dealing with the Army Corps, federal agency, as well as the state agencies, perhaps for other environmental permits.
One of the more recent concerns that has developed as a result of the large storms we've experienced over the past decade, such as Katrina and Hurricane Sandy, is mold. When you're concerned about mold, you want to look to see if there are any wet areas or mold-like staining in your property. If your building is right next to a wetland, it would be advisable to sample for mold. If there's prior water damage from a fire, or storms, or flooding, it could be very likely there's mold in your building, which again can be costly to remediate. There is testing. There are several methods. There's a do-it-yourself method, which you can pick up at most local hardware stores, which involves setting out a little petri dish with a substance in the bottom and collecting any mold spores that may fall into it. You can also hire a professional consultant to come in and take air samples or swab samples of specific surfaces that are suspect of containing mold. There are several ASTM standards dealing with mold. The one that's most pertinent to this discussion is D3273-12, which is a standard method for testing for mold on the surface of interior coatings. Recent New York legislation is seeking to regulate inspectors, much like the asbestos inspector profession. It was signed into law in January, and it requires a licensure of mold inspectors, abatement, and remediation contractors. It sets the minimum work standards for mold inspection, assessment, and remediation specialists. And much like or just like the asbestos regulations, the intention is for the Department of Labor to regulate that.
The very interesting thing with this legislation, and when the governor signed it, he had the following approval memorandum. He said that this bill would impose a licensing requirement administered by the Department of Labor on businesses and workers engaged in mold assessment, remediation, and abatement. However, it contains technical and substantive problems which the legislature has agreed to address in additional legislation. On the basis of the changes reflected in the agreed-upon chapter amendment, I am signing this bill. So, it's been noted, the Labor Department is going to come up with rules to implement this, but the governor, when he signed it, was looking to the legislature to follow up with additional legislation, and I am just not quite sure when or how that's going to come to be. So it's going to be very interesting to see what finally comes out of the Department of Labor.
Another pressing issue to investigate is the presence of radon, which is the second leading cause of lung cancer in the United States. Radon is a radioactive gas that's typically associated with shallow bedrock. It comes up from the bedrock and infiltrates into the building structure. It's easy to test for, and much like mold, there are at-home do-it-yourself methods to test for it, which involve hanging essentially a piece of foam in the breathing zone of each level of the building, and then sending that foam off to a lab for analysis. There are also professional testing consultants that can come in and do a more accurate survey. The EPA has established an action level for deciding when you need to, quote, do something about the radon in your home, school, or workplace, and that is 4 picocuries per liter, which is simply a measurement of radiation. There are several ASTM standards that can be referenced. E1465-08A is the standard practice for radon control options for the design and construction of new buildings. And if you have an existing building you need to remediate or mitigate radon from, you can refer to E2121-13. Mitigation is relatively easy and fairly inexpensive, and usually involves just installing some PVC pipes under the basement floor slab and venting them to the outside with a powered fan.
Ben, for radon, do you see it recommended for use in commercial properties, or, given our audience, colleges, universities, for classroom areas or study areas, or is it just really for homes?
I would be concerned anywhere people are spending a large amount of their time. So if you're spending 8 hours in a structure, I would think it's perfectly reasonable to measure for radon.
Is it just the basement and the first floor, or is it beyond that?
It's generally all the levels of a building, although if you get up higher and higher, for instance, in a downtown high-rise building, you're much less likely to experience at the upper floors. Another out-of-scope item that can impede development of your property includes ecological and historic resources. There are online resources you can look at. Specifically in New York State, there is the same mapper that we discussed earlier for identifying wetlands will identify areas of threatened or endangered species or natural habitats that can't be disturbed. There are a number of ASTM standards that can be used when assessing for ecological resources. However, most of these deal with specific uses. For instance, if you're going to apply a specific chemical to a field, there is an ASTM standard for that, or specific species, such as mussels in a creek, that can impede your use of withdrawing water from that creek. A particular note up here in New York are Native American lands. Coming across a ancient Indian burial ground or artifacts will certainly hold up development of your property.
When one is doing a project in New York, there will be a need to do an environmental review under the State Environmental Quality Review Act if there's any discretionary permits that are in fact in play. This is off topic a little bit, but it is something to be aware of, that there will be a need to evaluate whether or not things such as endangered species are in fact on a piece of property for which a development is proposed. So again, this is part of a looking forward situation where one wants to perhaps get a sense of what the issues potentially could be when you know your development plans looking forward.
Concerns over lead-based paint have been around for quite a while. Much with the asbestos, prior to 1978, if your building was constructed before then, it's pretty smart to do a lead-based paint survey. The Consumer Product Safety Improvement Act of 2008 established a lead paint limit of 0.009%. That's 90 parts per million. If anything comes back higher than that, you know you've got lead-based paint. Housing and Urban Development issued guidance in 1997, or revised their guidance in 1997. And in that guidance, they suggest different frequencies of sampling. It depends on what the object is you're sampling. It goes as far as door versus windowsill. That sort of detail, and that guidance can be very useful in determining what you need to sample and how much of it. Obviously, if you have an old building, there are probably multiple layers of paint, and so each layer of paint would need to be tested individually. Again, as with our previous out-of-scope items, there are a number of ASTM guidance documents on this. Standard D3618 discusses the standard test methods for the detection of lead in paint and dried paint films. The liability comes from inhaling dust or children eating paint chips off the floor or deteriorating paint around windows and doors and that sort of thing.
Another possible rule that comes into play going on the EPA website is the EPA's lead renovation, repair, and painting rule. The website notes that it requires that firms performing renovation, repair, and painting projects that disturb lead-based paint in homes, child care facilities, and preschools built before 1978 have their firm certified by EPA or an EPA-authorized state, use certified renovators who are trained by EPA-approved training providers, and follow lead-safe work practices. In the college university setting, it may be that there's an opportunity to buy an older home, perhaps near the college or university, to be used as a child care facility or as a preschool. So this is how that rule, in fact, could come into play in this particular situation and the concern with the lead-based paint.
Staying with the lead theme, lead in drinking water is also an issue to be concerned about. This was first addressed in the 1974 Safe Drinking Water Act. Lead is unlikely to come from the source, your reservoir or your public water system. It typically enters the water stream from plumbing materials within the building that were installed prior to 1986. These can include chrome-plated brass fixtures and faucets, solder, and lead pipes. And it's more of a concern with the hot water system. Hot water tends to leach out the lead much faster than cold water does. While the EPA has a goal of 0 parts per billion lead in drinking water, the action level they've established is 15 parts per billion. There's really no way to effectively filter it out of your water, so if you have it in your building, it most likely is coming from something in that building that needs to be replaced, either piping or a fixture. Testing should be conducted at each faucet, each point of use of that water, especially for potable use. And ASTM standard to look at for guidance is D3559-08, which is the standard test methods for lead in water. Indoor air quality is also a recent concern that's recently developed. Generally, when one is concerned about the indoor air quality, an employee or employees may come to the organization or the business with concerns over symptoms they've been feeling. It's important to look at the use of the buildings, what chemicals are being used, what processes are going on in that building. If it's a manufacturing facility, what materials are being used in that process, what's being done with the waste. What was the past use of the building? Were chemicals stored there in the past? This indoor air quality can also go back to mold and radon we discussed earlier, and even asbestos if there is renovation going on. There are a number of methods to test for air quality. If we're concerned about chemicals, the common method is EPA TO15, which essentially allows for an 8-hour collection of air into a vacuum cylinder with a regulator to collect air over that 8-hour period. That's then sent off to a lab. Results will be compared to OSHA levels, the permissible exposure limits, which are concentrations of specific chemicals in the air that OSHA has determined are not detrimental to the employee's health over an 8-hour period. There are many ASTM standards to refer to when you're looking for guidance. One in particular is D7297-14, the standard practice for evaluating residential indoor air quality concerns. And as I touched on, OSHA strictly regulates how much certain chemicals can be in the air, and the limits are set per chemical. Regulatory compliance is something that should be looked at if you're purchasing or coming into acquisition of a property where there may be needs for permits. These permits can include air permits for air emissions from a manufacturing process, process wastewater stream management, stormwater permitting, emergency planning and community right to know act reporting, which essentially reports to the local emergency responders how much of certain chemicals are stored on the property. And then, of course, bulk storage tank permitting and management. An ASTM standard that's handy to rely on for this is E2107-06, revised in 2014, Standard Practice for Environmental Regulatory Compliance Audits. Barry briefly mentioned the PCBs earlier. These have been used in certain materials from the 1950s until 1979 and are commonly found in caulk, floor expansion joints, adhesives, and dry paint. Interesting to note that a frequent method of introduction to the paint was someone who had a little bit of extra oil that contained PCB, didn't know how to get rid of it, so they just mixed it into a can of paint, and now the wall behind your desk now has PCBs on it. There are many testing methods. If we're concerned about PCBs on an impervious surface, for instance, a concrete floor or a piece of machinery, we'll do a surface swab. If we have reason to suspect that PCBs may have leached into the soil, for instance, from a transformer oil leak or other oil leak, we'll take soil samples. And the number and frequency of those samples are determined by the size and area of concern. And as with the other items, there are a number of standards, ASTM standards, to rely on.
PCBs and building materials became an issue starting about 2007 with a report to the effect that the percentage of PCBs in caulking material could be very high, as a result of which there was some sampling of caulk that was done in a Westchester County school, middle school, in which was very high levels of PCBs. That then led to a concern about New York City elementary, secondary schools having high levels of PCBs and caulking material, which culminated in an agreement between New York City and New York City Construction Authority and the EPA Region 2 to evaluate the impact of the PCBs and the caulking material and the best way in which to manage those materials. PCBs are regulated under the Toxic Substances Control Act, which is a federal law, and the regulation is 40 CFR Part 761. There is no requirement to test for the presence of PCBs in caulk, which is what gives rise to the concern of people who are looking at caulking material in the school situation. But there is a requirement that if that PCBs is found in those materials at or above 50 part per million, it's considered to be an authorized use in the building materials, so that once you discover it, it must be removed. Also a concern of the leaching of the PCBs and the caulk into adjacent masonry. And anyone then dealing with removal of the caulk and that adjacent masonry, there are certain worker safety consideration and OSHA standards that have to be addressed. So the caulking material is considered a PCB bulk product waste that in fact needs to be handled in an appropriate manner under the rules and disposed of in an incinerator or landfill. The material which has now been impacted by the leaching of the PCBs from the caulk, the adjacent masonry, that masonry is considered to be a PCB remediation waste. And there are certain disposal alternatives which are set forth in the TSCA rules. DEC gets involved as well, because if the material has 50 ppm or more of PCBs, you're dealing with a hazardous waste. And so you get into all the different hazardous waste rules, depending upon the amount that's generated, your large or small quantity generator rules, regulatory fees, special assessments, need for using permanent waste transporters, manifest if you're dealing with hazardous waste. I mean, even if you're dealing with a PCB impacted material less than 50 parts per million, it would still be contaminated. It would still contain PCBs. Still has potential issues associated with circle and state Superfund liability if that material is taken off for disposal at a landfill. So the concern is, again, renovation. You're buying a piece of property. You know this property has been constructed or renovated during the time period that's been indicated, the 50s into 1979. So it's a potential issue, a potential concern that there could be a cost associated with operating and, in fact, then renovating that facility.
This is an interesting standard that we can rely on when we have to do a phase 1 for a large rural or farm area of 120 acres or greater. E2247-08, which is approved for use by the EPA, allows us to rely more on aerial photography. We can use aerial photos to identify key structures and areas to visit, and provides for options if we can't access the site. For instance, if it's up the side of a steep mountain where there are just vegetation is just too thick to get through. That can include remote viewing from off-site. One of the more interesting parts of this standard is an expanded set of records review. In the early 1900s, there was an outbreak of Texas fever throughout the southern and Midwest states and even beyond in cattle. And it was determined that this fever was spread by ticks on the cattle. The states started in 1906 to enact compulsory laws requiring treatment of cattle for the ticks. This was done by cow dipping, which involved dipping the cattle in a solution of arsenic or sometimes crude oil. And that would kill the ticks, and the cattle would then be free of or not be in danger of the disease. However, those cow dipping vats and ponds present problems today. So it's important to look for those when we're looking at old farmland. And then finally, we look at mineral, oil, and gas development maps. These are important because we can find waste pits associated with old oil and gas wells. We can find oil and gas wells that we may not know are there from a surface observation. And it's important to note that even in New York, there are quite a few of these. The Finger Lakes has hundreds of gas wells that we probably aren't even aware of as we're driving by them.
And that brings us really to the end of our two-part webinar series. I just want to leave with you a couple things. The first is the date, October 6, 2015, when this new standard, in fact, will become the exclusive standard for use to satisfy the Phase 1 Environmental Site Assessment Standard under the EPA rule. And so one needs to be mindful of that. Our first webinar talked about some of the new terms, and so those are ones that one should become familiar with because they will become the standard here going forward. And the various non-scope items, and the thought that, again, the ASTM standard deals with remediation liability, doesn't deal with regulatory liability. It's been noted the situation where you purchase a piece of property that has some permitting issues, how important it is to, in fact, do an assessment as to whether or not one is in compliance with the various regulations, because that can have a cost associated with the owner owning and operating that property. And then the various non-scope items, which are environmental in nature, may not require some immediate remediation response, but in terms of developing, managing that property, they do represent a potential cost, and again, depending upon what the purpose is in buying the property and its ultimate use. So I'd like to, on behalf of Ben Height, I'm Barry Kogut, and I thank you very much for attending our webinars. And you have our information there on this final slide if you have any follow-up questions that you may like to email to us. So again, thank you and have a good day.